Defamation is one of the most commonly alleged torts in workplace investigation lawsuits. It arises when a false statement of fact is communicated to a third party and causes harm to an individual's reputation. In investigations, these claims can come from different directions. A respondent may claim they were wrongly accused, a complainant may argue they were labeled dishonest, or even witnesses may say their statements were misrepresented. Legally, defamation is generally divided into two forms. Slander refers to spoken statements. This could include an investigator verbally accusing someone of misconduct in front of others or making damaging remarks during interviews or workplace discussions. Libel refers to written or recorded statements. In most cases, the investigation report itself becomes the central document in dispute if it contains inaccurate, unfair, or unverified conclusions. In some situations, allegations of criminal or serious misconduct may fall under defamation per se, where harm to reputation is presumed because of the seriousness of the accusation. However, investigators are not without protection. The law provides several key defenses. The strongest is truth. If the statement is accurate, it is not defamation. Another major protection is qualified privilege. This applies when statements are made in good faith, without malice, and shared only with individuals who have a legitimate need to know as part of the investigation or decision-making process. In some cases, internal communication within an organization may also be treated as non-publication, further reducing risk when information is properly contained. There are also situations where this protection can be lost. If statements are made with malice, meaning intent to harm, or with reckless disregard for the truth, the privilege may no longer apply. Overstating allegations or making conclusions without proper evidence can create significant legal exposure. Another risk is excessive publication, where findings are shared too broadly with people who are not involved in the process. Finally, investigators should be aware of broader reputational risks, including defamation that spreads through digital channels or situations where terminated employees are required to repeat reasons for dismissal to future employers. In practice, the key principle is simple. Defamation risk is managed by disciplined communication. Stick to verified facts, limit disclosure to those who need to know, and avoid labels or conclusions that go beyond the evidence.